Good afternoon, 3 o'clock, Friday, the 13th. Do I take your chances today? I will call the June meeting to order and ask you to join me in the pledge of allegiance.
United States of America, to the republic which stands one nation under God, indivisible, with liberty and justice for all.
Okay, so, first order of business. Have members of the board have an opportunity to review the minutes of the May meeting? Any comments? I hear a motion to accept those minutes. Second, all in favor? Aye. So we found that. There is no old business on the table, so we have one item of new business, the application of Hunkus and Monica Philp. Who's got the name? It pertains to 39, got it, Sag Road. Application 5 of 2025, and it's a request for an area variance for height from 32 feet to 35.05 feet, and an interpretation of the building inspector's determination. So, Wayne, you want to?
David.
I'm sorry.
It happens.
Apologize.
You're not the first.
I'm a little dazed there. Maybe it's because it's June 13th, or maybe it's because other world events that are occurring as we sit here.
For the applicant, Rudy Gilmore, Junior Greenberg, Troy, 2317 Montauk Highway, Virginia. As the chairman indicated, we're requesting a height variance for a structure that was already constructed. I think it's important at the outset to note that this structure was built with a building permit. There seem to have been 2 errors along the way. Our architect designed it at 34 feet change, and John approved it at that height. We've provided that documentation, and it would appear to me, and they can certainly speak for themselves, that we all concentrate on material as opposed to height, which is sort of the basic thing, and you miss the forest for the trees, but this was an honest mistake that didn't get caught. So we're requesting that height variance.
Excuse me, what are the 2 errors? You said there were 2 errors.
The architect,
Yeah.
when he designed it at 34 feet and change, and then John issued a permit based on those plans.
I'd like to add one more person is the builder. He built it, so he should have caught that.
So let another person. So at this point, I think I'd like to take the interpretation first and then go to the variance request. And I'm in an uncomfortable position. I've worked with John since the inception of the village. I have a great deal of respect for him. I think he's one of the more highly respected building inspectors on the East End. But we disagree on how to measure height. Pat, could you pull up the code section? Your zoning code deals with height in 3 different sections. First, it's in your definition section. Defines height. The second place that we see it is in 245-6, where there's a reference to the attachment, and that's where we see the setbacks and height, and that's where we first see the proportions go as high. And then I think, the real operative section here is 245-42. And at C2, where I've highlighted it, we need the measurement of height is from existing natural grade done by a surveyor at and along the side of the building or other structure fronting on the nearest street. If I get this right, and I'm sure John will correct me if I don't, but the building inspector's interpretation is that there's measurements on all sides across the entire front of the property. Our position is that the measurements should be taken at and along the structure itself, and I think that's what the code says. If I could approach the So the real difference is the building inspector said that we needed measurements here, here, and then you come along here, 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 and then this side. Our position is that the measurements should be taken here, or surveyor added that one in, here, 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 and then here, where the structure is, and I think that is consistent with the code. And you know, I didn't want to disagree with the building inspector lightly, right? But it is, I think, more than half a foot difference. So the variance as it was advertised for was 35.05 feet. And if you adopt our interpretation of the code, we would be at 34.44. And I've provided surveys of each that show both measurements and those are the numbers. When readers of codes or statutes or statutory construction, the rule of that is that words are supposed to be given their ordinary meaning, right? And you can't read a code section such that you're making the words superfluous or that they don't matter, right? The words matter. The legislature, when they adopted the law, sort of acted along the structure. So it's our position that you measure it that way. Another challenge I think with the building inspector's interpretation is it's not acting along the structure. If I can approach again, this property, the grade goes up as we come back. If you look here, it's 41 feet, and here it's 38. Down here, the highest elevation is 33. If we took measurements along here, my guess is that only half of that building would be over the 32 feet. As the elevation gets higher, the building gets smaller. And in zoning, we measure height from the ground up. So I say all of that, I put that in there. I think when you're requesting a height variance, every inch matters. And we'd ask you to adopt that. I think it also demonstrates sort of the arbitrariness.
I'm sorry, but if we adopt that, it doesn't solve your problem, right?
No,
It's still,
because we
it's
still need
still
a
too
height
high.
But lessened.
That's too high, but too high.
Yes, still too high.
So two more questions.
Sure.
The southwest corner elevation, do you know what that is on the survey? And the northwest corner, what's the elevation on the survey? In the front of the house at before the house was construction, what's the elevation for that? I can't read it on the plan.
This 28.9 here
28.29.
That's the
in the front corner.
29.
And then 30.50 as we come back, the property slopes up and it slopes
So
up.
in the center of the house, from the setback, do you know what the elevation there is on the existing prior to the building?
This elevation is 32.63 and that's 32.69.
That was before the house was put up.
Yes, yeah, prior to construction, the surveyor has
32.6.
.6.
Okay.
And it's this part of the structure that violates it, the rest of the house is complies. So that's our request for the interpretation. That being said, we still need a variance. And with respect to that, I think the benefit to the Thopkins is clear here. You get to retain the existing structure. They can maintain the architectural integrity of the existing building instead of trying to lower the roof. And I have with me a contractor's estimate, which I apologize for getting it to you during the public hearing, but we just got it. The estimate to fix the roof is $207,000. And then there is, of course, the lost time taking the roof off and putting it back on. the detriment here, I think, is very little, and I think it weaves into the character of the neighborhood. And I think that argument can best be summarized by the now 7 letters that you have in support of the application. Each of the surrounding neighbors has expressed their support. The last neighbor's letter came in this afternoon, and it was accompanied by a plan. I've got a bigger version of that and plantings that we have agreed to do, so I'll pass that. And we have committed to doing those plantings as is shown on that plan. So I don't.
The highlighted Leland Cypress plantings.
Yes.
Reference to.
The plantings are in red and the silver's in red. And it's along the driveway that separates the French property or the Thopty property from the Wilford property. The Wilfords have a access to their house, and they, I believe, are probably the most impacted by this. Submitted a letter of support. One of the things that has surprised me is that the neighborhood is unanimous. And I don't think that I have seen that, certainly not in Sagaponic or in any of the other zoning boards. And I was really, I don't want to say shocked, but I was surprised at how eloquently the people in the neighborhood described what was going on, and I was particularly taken with the letter from Miss Dunlap. If I could, I would read it. I think it encapsulates exactly the character of the neighborhood argument. She says, myself and many others in the neighborhood think that the house being built there is beautiful, and that they have managed to mix modern elements with classic farm-style structures, thereby blending in while also enhancing the look of our neighborhood. The extra height on one of the gables does not bother me at all, and I dare say that no one would be able to see it with the naked eye. Most of the houses around the property are situated much higher up due to the natural slope and grade, and the other properties are completely shielded by trees. From the road, the only thing you see is a beautiful house that sits back further from the road than most have. And that will look like it has always been there when it's completed. I think that really encapsulates our argument on character of the neighborhood. The next prong in the test that we need to look at is alternatives. As I said in the beginning, this house is already constructed. So there's no alternative but to either take the roof down or get a variance, and that's why we're here today. So there are no alternatives but the variance. The next prong that we need to consider is substantiality. You just. To show the substantiality of it, and actually the lack of substantiality, so I should put it, if I can approach it in. We've done 2 lines across. The red dashed line is the building inspector's line with his interpretation, and then the lighter gray one is with our code interpretation. And you can see that it's just a small part of the upper part of the roof that exceeds it. So it's not like it's the full roof across that exceeds it. It is this small portion. And based on the little amount that's over either of those lines, we would submit that the variance request is not substantial. I'd also note, like Ms. Dunlap had in her letter, that this part of the structure is set 85 feet back from the street, right? It is, the setback there is allowed to be 60. So I think the height is further mitigated by the setback. The next prong that we need to consider is impact of physical and environmental conditions in the neighborhood. And first of all, there are no environmental impacts. In this, it's a minor exceedance of the height. And the New York State DEC has been clear that area variance applications are type 2, which categorically determined will have no impact on the environment. So this is a type 2 action under SECRA, and there's no environmental impacts. The physical conditions of the neighborhood, I think, are again answered by the neighbors, 7 neighbors that have come out and agreed that this will not create a negative impact. With respect to the self-created hardship, you've heard the story. There were 3 mistakes that were made along the way, and to the extent that we had control over 2 of those parties, I guess you could call it self-created hardship. But the law and zoning is pretty clear that the self-created hardship alone is not fatal to area variance application. I would submit that's the case today. We've submitted a statement in support. It has some more evidence in there. I would ask you to read that. And I'd like to leave you with 3 thoughts with respect to this application. 1, this was an honest mistake by 3 different parties. Nobody was trying to get past the height restrictions. This came to light as a result of a complaint, and that complaint showed the structure when it was framed, but didn't come into the village until it's fully complete. And it is unfortunate that it didn't come in earlier, because the Thopkins could have taken action to come into conformance, but getting the complaint at the late date when it was completed foreclosed that opportunity. The second thing, and I've said a couple of times, is all the neighbors enthusiastically support the application. And then finally, we just showed you the slide where the exceedance of the height is quite minimal. It's just the peak of the roof. It's in an attic. There's no real benefit to that area. It's not habitable space. It's not going to be used, and I think highlights the fact that there was a mistake. And that would conclude our presentation. We can try and answer any questions. We have the architects here tonight.
The architect's here.
Yeah.
We like to hear from him. I would like to hear from him. Yeah.
Good.
Read these. Very good. Copies, no copies.
Before we go forward, I have the affidavits mailing and posting. Thank you.
My name is Brian Foster. I'm Matt Bidner. And we're the architects responsible for the design of the residence at 30 Sag Road. We just want to take this opportunity to share architectural thinking on the project and explain how the design was developed with sensitivity to the character of the village of Sacaponic, and provide context for the minor unintentional zoning deviation related to the. So our goal was to design a house that blends quietly and respectfully into the surroundings. To achieve this, we selected a restrained palette of traditional materials, cedar shingles, natural stone, and just wood trim, and something that reflects the architectural vernacular of the aesthetic. We also minimized large areas of glazing and avoided expressive and overly modern gestures, choosing instead to emphasize simplicity and timelessness in both form and detail. In the massing of the roof lines, the house was inspired by a simple, familiar form of local barns and cottages, not too different from the room that we're actually in now. We incorporated these traditional gable roofs and straightforward geometry to help the house feel rooted and setting. And these decisions were made with the intent of contributing positively to the visual image of Sacaponic and creating a home that feels in scale to the surrounding community. We finished the finished structure exceeds the maximum allowable height by a small amount. an overage that was a result of genuine and unintentional error made during the design process. While working to comply with the pyramid law and meet all the zoning requirements, we miscalculated in the total allowable building height in our construction drawings. And it was an oversight. Now the result of field changes were adapted to maximizing the wall. So we take responsibility for the mistake and just want to reiterate that it occurred despite our best efforts to design code. And house remains modest in scale and character with forms and proportions that are reflective of village traditions. Although the overage is minor, we acknowledge its importance and hope that the context provided demonstrates our good faith behind the structure. So in closing, the home at 39 Sac Road is designed with care, restraint, respect for Sagaponic's architectural heritage. We regret the height discrepancy and hope the statement makes it clear that it was an unintentional error on our regard. We remain committed to building with integrity, contributing positively to the village. Thanks.
Did you take measurements along the elevations before designing the building, or was that a survey, or where did those measurements?
I think that was
This is a survey. He's not here, I think.
No.
You just accepted the elevations that you received from the survey when you designed the structure.
Correct.
Any other comments, questions?
Yeah, from the top of the foundation to the top of the peak, what was the measurement on your plans that you drew?
I believe it's highlighted as 34 feet.
So ask me a question, answer the question. How does that happen when the code says 30 feet?
It was,
The CAD system did that?
no, it was a mistake on our part. We were paying attention to the pyramid law and following that.
Isn't that why we hire people like you to do that
Yeah.
and not to have a problem later on?
I agree.
So the hardship is on the homeowner to try to get this remedy. So they gotta go out and hire a lawyer, have all these people here for support on your mistake.
Yes. It's something we,
So,
we
you know,
take the codes very seriously.
I'm in favor of going to the village board now and making another law, which I don't like laws, and telling from now on, if these architects are gonna design something that our building inspector does not catch, or final framing inspection doesn't catch the height overage after the plans, I can see the building inspector missing this because he's got a lot of work. He works 3 days a week for the village, is part-time. But you guys went to school. You're supposed to know all this stuff. You're supposed to know the code. And now this has happened. You've cost these people a lot of time and effort and hardship.
No, we're very sorry for that.
And the other part of it is the builder. Now, the builder goes, he should have had just as much say in the height when he built it. He should have known that it was over the code height. They should have known that. So to me, in fault are three people. First, the architects, second, John Woodsma, and third is the builder. Whereas I can see that you are the people that basically created this hardship for everyone here.
I agree. We take the codes very seriously. We do our best to follow them to a
But
T.
it always seems that it always happens the same way. Now we're sitting here, everybody comes in, they need a variance because they drew it over height. It happens all the time. So I'm gonna suggest that our village board make another thing in there. There should be some kind of finding or something that has happened unbeknownst to an oversight from the building department. And basically the people that really are at fault is the architect and the builder, because they both built it. That's about all I got to
Let's
say.
bring it back to the application. I appreciate the comment. I think it's a very important one, not just in this circumstance, but we've had numerous applications with
Very
people
well.
coming in and asking forgiveness often attributable to alleged errors. I truly believe this was an inadvertent error here on the part of the people that he mentioned, and I'm not saying anyone did anything intentionally, but there are cases where much more likely there were intentional exceedances where they said, oh, well, it's small, or the zoning board will go along with it. And it's a creeping problem, and it's a problem we need to deal with. Again, our role as the zoning board, this problem has come to us, and we have certain standards that we apply in whether to grant a variance or not. And our remedies are largely limited to grant the variance or not, or with some variations. Richard's point was outside of the scope of this hearing in terms of whether there should be some remedy for these errors in the future. There should be some accountability at least, and the accountability shouldn't be the denial of a relatively modest variance to the homeowner who had nothing to do with it. So the point's been adequately made, I think. If you want to add something, David, before we proceed.
There was a discussion on good faith, and this is a copy of the plan that was submitted. So just, there was no underhanded effort to gain
No, I
height
think
here. That's what was put in,
Yeah.
in this particular instance.
I don't think anybody on the board here believes to the contrary. Okay, one other question that I have for Chris Bianco, just as a legal matter, because there are both legal and issues here. To the extent that there was an error on Zoom, by the way. Yeah, you can see it. To the extent that there was an error by the building inspector, is the village bound by an error by its agent in this context legally?
No, so typically, what the courts have said in the past when building inspectors make errors, even when they issue COs and building permits that they made an error, is that they are not equitable. Estoppel does not lie against the village, so they can make a mistake and then retract it, and the owner doesn't have any sort of property right or right in that grant or that permit. So,
Okay,
yeah.
that confirms my understanding, and I seem to recall a case in New York City,
Parkview Associates.
the one with 9 stories had to be taken off a building on East 96th Street, right?
Board of
Okay.
Appeals case.
Yeah, so just to be clear, we're not bound by the building department error, although we certainly take that into account in terms of the context of this. And I still remain a little bit unclear as to the manner in which the measurements are made, because one of the things that we need to do is determine whether the interpretation of the code by the building department, by John, was or wasn't correct, and if it's ambiguous or it should be clarified to avoid errors in the future, I'd like to be able to do that. So the language of the code says that it's at and along the side of the building or structure fronting the nearest street. So your contention is that the measurement should have followed the configuration of the front wall with the setbacks, et cetera,
Right.
as opposed to taking the side closest to the frontage. I don't quite understand the discrepancy.
I think the difference between our interpretation is that Mr. Woodsman took it from the entire frontage, property line to property.
At the point that was closest to the street. In other words, because there's setbacks on the
Well,
property.
I think if I understand your question, he took it at and along. He took it at and along, he just added 2 extra points that were both
On the side property lines, which were not along the structure itself.
correct. Those two measurements are the 2 that I think.
So then there are 2 issues in my mind. One is that the frontage of the house is not straight across, right, and there's setback.
Right.
So there
That's
are,
why I asked the question of the elevations on each end of the house and the front and where they took the marks from.
Just because I talked, sorry.
we'll get John, but I want to hear what his interpretation was first.
So this is the structure,
Right,
right? So we have an elevation here, an elevation here, an elevation here, and an elevation there, an elevation there. And that's where we believe that it should be taken. I think Mr. Woodsman will say that he added this elevation and then an elevation over here. To his calculation, and the property grade moves up towards the middle and then up towards the back, so we believe it's.
so the northerly point that John added was actually at the highest elevation of LaSalle.
No, it's 33 here and then 3120.
No, it's lower.
Lower, yeah. Yeah, the property.
Oh,
kind of-
it
correct, yeah.
elevates to the rear, to the east. not
And
to
then,
the-
but also up to the center. Right, so those two, disproportionately, I might say, affected that 35.05, but we think it's these numbers.
An average
Of those.
Those points.
Right.
Now, you identified an additional point, which is not at the facade of the building, the one at the very northwest corner. There were two measurements that you did.
I was responding to a question from Mr. Thayer.
Yeah.
It was 30.5.
That's here.
Yeah.
Right, that's in the front, right? The property comes up and then it slopes up significantly after.
Well, your measurements were actually on the front facade of the premises, at the wall itself, not at a consistent setback from the frontage. Where the property is set back, part of it, the northerly part where it exceeds the height, right?
Right, so we had two elevations, the
Yeah.
33 and the 32 point.
Okay.
So
that's
two,
where-
5, and 7.
So you took two elevations at the northerly side of the property, one of which was at the front of the structure, and one of them was at the front of, I guess it's a parking area, right? Is that?
No, this is, the dotted line is a building envelope,
Yeah,
right? So this is the end of the structure here, and the
Right.
elevation there is 33.
yeah,
We added this one, and frankly, I
that's the
didn't,
one I'm asking about.
yeah, frankly, I didn't agree with the surveyor adding it, but he did. And that's what the survey represents, and that's the evidence.
Okay, but that's why I'm trying to understand
Right,
exactly that point that you just
it's
mentioned.
32.75.
What the logic of choosing that point when it's not on the front of along the front wall. Just one moment, because I'm glad you have some sort of answer, but you understand what I'm inquiring
Yes,
about.
yeah, and
Because-
I had the same reaction.
Okay, adding that point, which is not along the front wall, could influence the elevation of the measurement.
It was
And I
pretty-
don't understand the logic, well, it
It's
may
pretty
be.
minor, it's pretty
It
minor.
may be minor in this instance, but whether we're accepting that for definitional purposes. As that people can arbitrarily pick points which aren't along the wall and add them in there to change the average presumably. So that's all I was asking. So Mr. Tafti.
May I?
Yeah,
Because I was the one talking to the surveyor and John at the same time. The three of us tried to figure this out. So may I approach?
yeah, please, and announce who you are for the record, so. Yes.
Hampus Tofte, the applicant. And may I approach?
Yeah,
The reason I think David doesn't know why these points are here, because he wasn't involved back then, it was John and I trying to read the code together, and we're going back and forth. And I think the discrepancy is actually how we did in the application, we did a straight line. Because we think that makes sense to follow, might not be, even though the code says at and along the facade. And that's what David says, and then we would have a higher elevation. But the only thing really John and I disagreed on was to go along the facade, but also include points all the way out at the property line. That's the only difference. I read it and Mr. Gilmartin reads it as at and along the structure. Hence, but I agree there should be probably a straight line. So there should be those 5 points that you see here. That gives you what you have in this second survey there exactly. It could be argued that it should be exactly it following the facade. That might be trickier for you in the future, but I think that's what it should be. But what I tried to agree with John was do a straight line, but not all the way out to the property line. Because if you have a property like ours, in our worst examples, that sits on a hill.
Yeah.
You're gonna be affected by the lowest points out here. And that's not really what we're measuring where the house is being built. So our interpretation is a straight line at the minimum in front of the building, but not including at the property line. There's a wide lot, could be a lot. That's why we have this point here was when I originally thought that the relevant number was where the actual structure is.
Yeah.
So that's why we have these points here.
All right, thanks for addressing that. So I understand that the discrepancy between your interpretation and John Woodsman's interpretation has to do with the extensions of that front line to the property line beyond the extreme edges of the structure itself. And then there's a separate issue that I was addressing, which is if it's along, if the code says, you know, along the side of the building, then does it need to follow the configuration of the building, which has setbacks? In other words, is it a straight line? And is that from the point which is closest to the street? Okay, so I'd like to hear from John Woodsma. If you would give us an explanation of your interpretation and whether we now seem to understand what the issue is and whether there should be a clarification of the code or, you know, are you comfortable with the way it is?
I find it to be fairly clear, however, that's because the person who wrote a lot of zoning code out here was Tony Toho, our former village attorney. So when I actually came to some of these original ones where we had to figure out the average elevation of grade, because there are a few topographically challenged pieces of property in Sagapon, not that many, but we have. And he said that, you know, it is at along the front, the closest point of the facade of the building to the street. However, it is the average elevation of the property. That's what average is. It's not just the spot in the middle where the house is to be built. It's the average of the property. So you take it at this point from the property line to the property line. And that was how I was taught to do it. And that's why I do it the way I did.
So it's the average elevation of the property at the front line of the structure, not the average of the points on the structure
Average
itself.
elevation of grade along the front facade of the building.
So the along the
existing-
front facade doesn't
existing.
dictate that you follow the structure.
Yeah.
It just says that that's where you take your measurement from property line to property.
It's the average existing property.
Yes, which is why we have
Yeah.
in place the topographical marks on the survey before we issue permits.
Average.
Yeah.
Okay. So in this case, the line is not from the north of the property, which is 30.5 to the south is 28.9. You don't draw a straight, contours don't go in a straight line. They can go back and forth, correct? So therefore, that's how the average is.
Yeah.
That's why Toho Road has the average.
No, I understand the
I'm in
average.
favor of the interpretation of the village.
I agree that it was intended to be the average. The question was an average of what measurements and whether it's the average of the elevations for the entire width of the property or only for that portion of the width of the property in which the structure lies. Is that fair?
That's right, we just average too.
So that was the issue.
So another question to the average of the existing contours. In this case, this property, the northern part of the structure is the highest part of the structure, correct?
Yes. The middle of the property.
So
is higher
therefore,
than
the average from the northwest corner of the highest structure to the southwest corner of the second story of the first section of the north section, is that the average that was at 35 feet?
somewhere around there, but it is
So you
actually,
take the average of that area within the 35 feet?
we
or the
take the
whole property?
points, the way that I do it is I take the points from the property line in the north and we take spot points along the way at the closest the closest part of the facade to the street line. And that way you can figure out what the average elevation of the entire property is.
I understand, but I was wondering in this case, if you took the two existing spots that the existing areas in violation of the code would lessen the height.
Yes, it would. There is a knoll on this property. So the middle of the property is actually at a higher elevation than, say, the northern point and the southern point. So it kind of comes up and back down like a speed bump.
So
Not much, but
So if we accept your interpretation and agree that it should be the entire width of the property at the location of the facade of the dwelling, which is closest to the street. Would it be helpful to clarify the language of the code at all, or you think that it's sufficiently clear? Because obviously, there was a differing interpretation of that.
If you wanted to make it crystal clear to my interpretation, then you would say from property line to property line.
Yeah.
And if you wanted to agree with the applicant and make it crystal clear, then you would say it's at and along and only of the structure.
Yeah, okay, I think that that's an excellent point. Question is, this is a matter of first impression for me.
But the other point to it would be if the property did undulate up and down. So therefore here you're building a piece of property where you're building the architects would understand this. So you'd have a section on the lower piece of the property at elevation, say 2, and the elevation on the left part, which would be the north part, at elevation 6 with steps inside. So therefore, the interpretation doesn't work for situations that involve with that. But in this case, it's flat across, there's one height, correct?
There's a knoll in the center.
There's a
house
variation
itself.
of
The house itself is
footprint.
correct, yes.
So I'm just trying to get to the interpretation of what the code says. So it doesn't, the code doesn't allow for undulations of the property, even though if they did have a house higher and lower. That's what the point I was trying to make. So that could be an added thing to the code too. There's a whole, it can go on forever, you know?
No, okay, but as I said.
There are diagrams
There's
that
enough rules
actually do
already,
show
so-
the height of the house following the contour of the property.
Yeah.
And they're still in the code books, however, they've been disavowed decades ago. This is where the average elevation of grade came in.
Okay, so I don't wanna make too much of this. I mean, as I say, this is a matter of first impression. We've had our zoning board, I've been on it since the inception of the village. And this is the first time this issue in particular has arisen. So it's not a common problem. Furthermore,
Well, you're saying the height variance?
no, height variance is attributable to a discrepancy or a difference of opinion as to the interpretation of the average elevation.
Even with
So-
the interpretation, there's still the discrepancy in the 2 feet that I missed. That
Yeah, no, that's, okay, that's, that's an error that nobody.
We understand that.
That happens. My point is addressing the first issue as to the interpretation of the code and whether the code needs to be amended or whether this is such an infrequent issue as between an applicant and your interpretation. And whether we should take quasi judicial notice of the fact that the building inspector has a great deal of experience and bases his interpretation on one of the highly respected attorneys in zoning law who has written and served on many of these boards. And whether that discretion or ability of the building inspector to apply that knowledge and experience without having to change the code is sufficient to be determinative, so that if this issue had come to attention before the structure was built, you would make an interpretation and as far as I'm concerned, they would be bound by it. I mean, it's so we can discuss that offline, except it may be a necessary part of our decision here since they requested an interpretation. So we can discuss that after we close the hearing because that's a legal matter as to whether we think we should have a clarification of the code or rely upon the judgment and the interpretation of the building inspector, okay? So I appreciate your elucidating that because it wasn't clear to me, and now I understand what the issue is. All right, so I think we can move on from the interpretation phase to the actual variance issue. And before I hear from the board, we do have, 7 letters that we got in support from virtually all of the neighbors. I mean, I think that's significant. If any of you want to speak in addition to having given a letter, or if there's anyone else here who wants to speak either in favor of or in opposition to the variance, I welcome your comments. Okay, hearing none, then
Hi.
I.
Sorry.
Oh, you got somebody online, yeah.
Hi,
Yeah.
good afternoon, board. Catherine Bowers Cray. I represent the neighbors to the north, Mr. and Mrs. French. A letter was submitted in support to the board. However, the support was including plantings that would be a condition of approval to screen the structure from the neighboring parcel. So I just wanted to bring that specifically to the board's attention. In the event the board is going to approve the application, we are requesting that part of the condition be those plantings.
Mr. Gilmartin brought that to our attention and provided us with a drawing that reflects the proposed planting of 10 Leland Stripes trees, which will begin at approximately 10 feet high, right along that driveway line on the north side. So we are certainly taking that into consideration, and he's indicated also that his client is amenable to that.
Yes. Thank you, board. Thank you, Mr. Gilmartin. Just wanted to make that clear.
All right, so any comments that you want to discuss or question that you want to?
I mean, I have comments. Looked at by itself, this is a perfectly, looks like a very nice house, and it is, whatever interpretation is adopted, it's a small difference, but it is a difference. So this house was built contrary to code, and in violation of the code. I'm sure everybody, unlike certain other circumstances, everybody's completely honest and acting in good faith. To me, that's irrelevant. The code needs to be complied with. And if you read the code, good faith and honesty are not, don't appear in there, and I don't think they're particularly relevant. What I think, as long as we're talking about changes we may seek to obtain in our legislation, zoning legislation, is the problem is, our powers are too limited. I'm not interested in making them, knock down their roof and spend $209,000 to, make it look like a hat or something different. But I do think that we have a serious problem. Just last month, we had another violation. We had a similar application. It involved a misplaced pool, and everybody said they were in good faith, and they probably, no, not a pool, a tennis court, a misplaced tennis court. It was a small difference. Yes, it was too close to the line, but it's a small difference, and everybody was in good faith, and the owner didn't know, and the tennis court guy didn't know, and nobody knew. And we can't have a situation where in this small village, a small village of intense construction, everybody takes this incredibly casual view and thinks that they can rely on somebody else, or we're going to be, of course we're in good faith, so we're going to get a pass. And I don't really know what to do about this because our powers are so limited, but I think at least as we did with the tennis court, we would need to make a note in our decision that we take this very seriously and we're not swayed by people's protestations, in this case, completely valid, of good faith. The rules need to be abided by.
I think you echo the comments that Richie made at the beginning of the meeting, and I generally concur with. I think we have a role here. We apply certain standards as to whether to grant a variance or not grant a variance, either with or without modifications. I take that role very seriously. I concur that we need to protect the integrity of the code, and we don't have a way of doing that without being overly punitive in certain circumstances if the choice is merely to deny a variance which meets the tests of not adversely affecting the neighborhood, particularly with the support of all of the neighbors, having no adverse environmental impact, being insignificant in size, even if it is a self-created hardship, to the point of whether the self-created hardship is intentional or inadvertent. But that is, we're discussing it at more length than we may need to in order to decide this variance application. But we need to be on record, and perhaps there can be something in the decision that again reiterates that we do not favor granting variances which are necessitated by errors in people's professionals who are responsible for abiding by the code, and that perhaps there should be some other consequence or remedy other than denying the homeowner their variance. That's something I see that our mayor's here, he might consider at some point beyond the scope of this particular meeting. So getting on to this variance application under the given rules and regulations that we are bound by, I am willing to close the hearing if there are no further comments and render a decision. Now, we've been counseled not to render decisions from the bench because things come up and there may be further discussion. Though I think we have indicated our inclination with respect to the granting of the variance. I think we need to think about the interpretation of the code portion of that decision. But I think we can still close the hearing because that doesn't require more comments from anyone here or us.
I make a motion to close the hearing.
So I will second that. We will close the hearing. And we will deliberate before we render the actual decision, which you will get, I guess, at the next meeting. There is nothing that is interfering with the completion of your construction or the occupancy of the home. Is that correct?
I don't think so.
Okay.
I'm in favor of rendering.
You want to render the decision? Okay, well, so.
I make a motion to approve the
Okay,
variance.
well, hang on, there's two things there.
Subject to the Chris's.
Well,
interpretation
so
of-
one thing is that we render a decision that would support the interpretation of the building inspector with respect to the code language as to the determination of the average elevation, right? And the second portion would then be to grant the variance, conditioned upon the plantings that were agreed upon. Okay, so is that amenable?
Is there gonna be a written decision?
There will be a written decision. This is just giving guidance to Chris as to what he should draft.
Okay.
I would also say you can't really approve it necessarily now because we have to figure out the appeal because that'll determine how big the variance is going to be. I know it's not a big difference at all, but just on that point, we want to figure out the interpretation question first.
David?
In light of the discussion, we would withdraw the interpretation. We just go forward on the variance.
Okay.
That satisfactory?
Yeah.
Okay. All right, so that becomes moot. It's been an interesting discussion and it will provide some guidance for the future. And it's in the minutes, but for purposes of our decision, then it's solely limited to whether the variance is granted or not. And I hear a motion
I make a motion
to grant the variance subject to the plantings.
planning and Chris's addition.
Okay?
Okay.
Second? I'll second it. All in favor?
Aye.
Any abstentions? Okay, so you've been silent, John. Is that,
Yeah, I didn't think we were gonna make decisions quickly.
okay, so we are rendering a decision on solely the variance, not the interpretation.
Well,
we are
we
gonna
are
subject-
gonna get the interpretation at some point, it just won't disappear.
No, well,
Well,
it's
it's
the
disappearing
interpretation, in the absence of an appeal of the interpretation, the size of the variance will be based upon John's interpretation of the code, which will be sustained for future applications and all, it'll be John's interpretation of the
I
code.
understand it's not an issue in this case.
Right. Okay, and the variance, basically, in terms of the 5 standards that we apply, as I said, no environmental impact, no change in the neighborhood, supported by the neighbors, insubstantial in terms of its size, even if it is self-created, and I disagree a little bit with Henry as to whether the self-created hardship was intentional or unintentional, does affect my decision as to how heavily to weigh that fact.
To me, it has an impact on what we might say, and if we had some kind of punitive authority, whether you would exercise it or not. It doesn't make a difference in terms, to me, in terms of whether you.
Just in terms of weighing how heavily we take into account the self-created hardship. Okay, I don't want to belabor it, so we have the motion. Motion's been seconded. It's to approve the variance in the height amount that we determined based upon John's interpretation of the code. And subject to the plans. All in favor?
Aye.
Aye. All right, so that's unanimous.
Thank you.
Thank you for your patience.
Thank you very much. Make a motion to close it.
And that being the only item of business, I have a motion on the floor to adjourn the meeting, which is second, all in favor. Meeting's adjourned. Thank you all very much. And good luck with the call.
Thank you very much.
Thank you.